Hello, everyone. Thank you for joining us for our first session on our frequent roundtables that we are planning to do at North Forge for the Startup Visa Program, where we are planning to have reputable and amazing immigration lawyers from all around Canada to discuss the new trends and the new, what's happening, what's new in the Startup Visa Program, what is exactly the strategies for the success in navigating the Startup Visa Program. So we are today inviting three of amazing immigration lawyer coming from Toronto. Basically, one of them are basically from Winnipeg, but they are based now in Toronto, and we will discuss lots of trends and lots of basic topics that everyone who is a stakeholder in the startup visa program. You shouldn't be only be applicant to understand and know these trends. Even if you are an immigration lawyer, a business consultant, any stakeholder that is working on the startup visa program has to be aware of these trends that going to be discussed today. So I want to start this session by the land acknowledgement. So we respectfully acknowledge that we are meeting virtually on the ancestral lands on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji Cree, Dakota, and Dani people, and the traditional homeland of Red River Métis people. Let me start by introducing myself. So, my name is Narmeen Saad, and I am the Director of a Global Entrepreneurship and the Startup Visa Program with North Forge Technology Exchange. So, thank you all for joining our monthly Startup Visa Program Roundtable. We will host reputable experts in immigration field to share the latest trends and useful insight around the Startup Visa Program. So, our agenda for today is that we're going to start with a welcoming note from our amazing President and CEO, Joel Foster. And then we're gonna go to a discussion by Greenberg and Hamid BC team. I'm gonna introduce one by one the three of the amazing lawyers, and then we're gonna go to a Q&A session, and then we're gonna go back to the networking place so that you can have a one-to-one talking and discussion with the lawyers. So for the housekeeping, you're gonna be when they start the presentation, you're gonna find four arrows at the top right corner of your screen. If you wanna enlarge the screen, just go there and click them, and you will gonna have like a big screen for the presentation of our speaker. So to kick off of the today, I would like to welcome North Forge President, CEO, and co-founder Joel Forster to the stage to provide you with a bit background about North Forge and its international expansion. So please, Joel, if you would like to join me on the stage, I'm gonna leave it to you.
Can you hear and see me? Okay, wonderful. Welcome everybody to this roundtable. I am so looking forward to the discussion. All of you are on this incredible journey of entrepreneurship and looking at coming to Canada and settling here. And I am so excited to meet all of you at some point. We want to walk alongside you in this journey and we want to help you. I am so blessed to have someone like Nermeen who genuinely cares about everybody's idea and wants to make a difference. Here in Canada, we are a multicultural country and we welcome everybody. We want to, innovation is something that is extremely important to us, and we can't do this without the help of all of you and your wonderful ideas and all the cultural gifts that you bring here that enriches us all. So as we move forward in this journey, I want you to know that we are here for you in every capacity. Please feel free to reach out to me. I am certainly, of all the programs that we run at North Forge, this is the one that is most dear to my heart. And I'm walking alongside Nermeen as she helps you. So as Nermeen mentioned, I am one of the co-founders of North Forge. I myself have helped over 500 businesses start across Canada in every industry, from restaurants and creating food products to fashion, opening up storefronts, to technology. And technology is very dear to my heart because this is what makes a difference in people's lives. All of you are creating something that is going to make a difference. So I applaud all of you, and I have so much respect for all you're doing. And I look forward to hearing what our incredible three individuals are going to be talking about. So thank you so much.
Thank you very much, Joelle, for this amazing welcoming and intro. I would like to invite everyone. If you have any Q&A, you're going to find at the right side a Q&A tab. Please add your question as our presenters presenting their ideas. And also, if you would like, you can apply them in the chat, and me and Grace will work into moving them into the Q&A. So I would love to start by introducing our speakers. First, I would like to introduce Nauman. So it's my pleasure to know Nauman for a while now. He is a very reputed immigration lawyer, and I would love to have like a long relationship, working relationship with him, as he is really a very straightforward and clean lawyer to work with. So Nauman Hamid is a co-founder of a Greenberg Hamid BC, a distinguished immigration law firm, brings over 2 decades of expertise as a certified specialist in immigration law, with a history of leading two of Canada's largest national immigration law practices. Nauman is a graduate of Osgoode Hall Law School and holds license in both Canada and the United States. He leads a full-service immigration firm specializing in processing a high volume of immigration applications, notably excelling in Canada's startup visa cases. Beyond his legal practice, Nauman actively engages in shaping immigration policy recommendations, collaborating with senior stakeholders in Ottawa. His commitment to enhancing the startup visa program in Canada is evident through thought leadership, frequent speaking engagement, and contribution to publications such as Lexology, the Canadian Bar Association, HR Association, and national media. As a board member of Talent Life Canada, Nauman passionately fosters connections between employers and the global talents. His influence extend to lecturing at esteemed institutions like Osgoode Hall Law School, the University of Ottawa, Faculty of Law, and MIT, solidifying his pivotal role as a key influencer in the realm of Canadian immigration. So this is the first speaker. The second one is Alif Maliki. Alif Maliki is the manager of the Startup Visa Program at Greenberg Hamid BC, a distinguished full-service immigration law firm. Greenberg Hamid provides elegant, efficient, and innovative immigration solutions to their clientele, ranging from some of the largest corporations to individuals seeking personal immigration services. Alif has been managing Hamid's SUV program for over 1 year now and has become well versed in the various nuances with their program. He has been deeply involved in the preparation and submission of applications, intervening in applications that are close to refusal, successfully reversing refusal decisions, and securing approvals after initial refusals. In the short amount of time that he has been involved in the SUV program, Alif has impressive track record of success and has filed over 100 SUV applications. Alif completed his undergraduate education at York University, obtaining an honor Bachelor of Commerce Theater for after. Alif pursued his legal education in the Sunshine State of Florida, where he obtained his JND, marrying his knowledge of the American and Canadian judicial systems. Over the course of his legal education, Alif has also conducted and participated in County Court mediations, dispositions, and earned a podium finish in mock trial tournaments at the regional level. Alif, this is too much difficult words for me, but thank you, Alif, very much for your amazing biography. So the last but not least, our third speaker is Pushkar Prihar. Pushkar Prihar is an associate lawyer at Grimberg Hamid. He has been involved in complex litigations before the federal court challenging visa refusals of various categories, including temporary and permanent resident visa, startup business class, family class, sponsorship. Pushkar specialized in high risk prior refused cases. He is actively involved in challenging the use of artificial intelligence and the procedure fairness issues that are involved with the same. Pushkar brings diversity and inclusion in practicing law. Being an immigrant, he is live to the issues being faced by newcomers and advanced submissions before the Immigration, Refugees, Citizenship Canada and the Federal Court. He is a member of the Canadian Bar Association Anti-Racism Committee, National Immigration Section, and Social Media Committee. Nauman, Alif, and Pushkar, please turn on your camera and mic, and the stage is all yours.
Wonderful. So thank you very much. Firstly, special thanks to North Forge today for allowing us to participate. I've had the wonderful opportunity of meeting Nermeen in person, and I just spoke with Joelle as well. And I can tell you they're very passionate and they're truly committed to supporting entrepreneurs and passionate about Manitoba as well. And that's the right starting point for this program, is starting at the right place, having the right intention. And I think we'll have a really good discussion today. Alif and Pushkar are great talent, very committed to our law firm, and looking to make sure that they make a difference in this program. And we have a lot of insights that we'll share with you today. So let me just share our presentation for a moment. We called today's discussion, Canada Startup Visa Program Strategies and Insights, Thinking 3 Steps Ahead. And we did that with intention because the SUV program has evolved and there's a lot of different considerations, whether you're an applicant or if you're a prospective applicant thinking about the program. And today what we'll do is we'll share with you the knowledge we've gained, having filed over 100 of these applications. And hopefully there'll be value in terms of considering the program. Today's discussion will have a number of different points. We'll start off by talking to you a little bit about the origins of the SUV program and where it is today, because it's very much evolved from the time that it was first formulated. We'll talk to you about the inventory, meaning the number of files. It's become an extremely popular program, and a little bit about individuals from around the world who have used this program and which countries have been in demand. And you'll see that it's attracted great companies from all over the world. We're going to get technical for a moment. We won't be too lawyerly, but we will do what's necessary. We'll talk to you about eligibility for the SUV program and also how to decode the regulatory requirements and policy guidelines. Over time, there's been more direction in terms of how the program should be administered. And it's important to understand not just the bare bones of the law, but what are the officers actually looking for? We'll talk to you as well about best practices and common mistakes that we've seen. In many cases, we've learned from our own experience acting for clients, filing applications and seeing the response from officers, both on work permits and permanent residents. But we've also had the benefit of individuals who filed their own applications or have been represented by advisors who are new to the program and seeing what types of mistakes were made. And hopefully we can flag those for you so that you can take the right action and improve your chances of success. One of the new features that we've been offering for our clients is something called an activity tracker. And it's really important because the bottom line in this program is once you're issued a certificate, you have to demonstrate your genuine intent to lead a startup and to ensure that the activities demonstrate your commitment. And we created a little technology that's been helpful. We'd like to show that to all of you today. Pushkar has joined our firm and has a lot of insight and tactical strategies in dealing with refusals or pushback And that could be from a visa post or even at the federal court. And our firm has spent a lot of time combing through the federal court decisions to understand the wisdom of what the federal court has said on issues of interpretation. It's an evolving area. It's still in the early days, but by taking that knowledge and sharing it with our clients, we've been able to position them for success. And there's some really interesting insights that I think everyone will benefit from. We'll talk to you about something that occurred last week, which I think is critically important. There's a new inspection regime, which is being issued for employers in the SUV program. So Canada has a general employer compliance mechanism to ensure that employers are acting honestly, truthfully, and are protecting the rights of workers, and also are genuinely active in the business they've described. And that's been rolled out for SUV applicants. And there's some direction that we received. Alif had a conversation for close to an hour. He wouldn't let the officer off the line until he squeezed him for all the information. We're going to share that with you today. And then we're big fans of this program. So we're going to talk to you about some of our success stories, some amazing startups that have come in, some obstacles that we saw in front of our clients and how we got across the line. And then we'll tell you what we think the path forward might be for the SUV from a policy perspective. Historically, myself and the other founder, Howard Greenberg, we've been very active with the department in Ottawa in sharing insights. And we've put forward now 4 different policy proposals on how to improve the SUV program, looking at success factors and risk factors, and it's been really well received. So we'll share some of that thinking, and we're happy to share our thinking with all of you, because as a stakeholder group, the more we work together, share ideas, the better this program will be, and it's in everyone's interest, particularly Canada. So just stepping back, it's quite interesting. When you look at the origins of the SUV program, I recall when the SUV program was released, there was a minister named Minister Kenny at the time who saw an opportunity. And the opportunity was, how do we attract some of the best talent from the Silicon Valley and convince them to come to Canada? And this has always been an issue where in the US, it's very difficult with their immigration system for top talent, particularly entrepreneurs, to stay in the country. And so he put up a billboard inviting them to apply for startup visa applications. And at that time, the program was only a permanent residence program. There was no work permit. And we were very excited. I remember at our firm, myself and Howard, we called IRCC officials. We had NACO, which was the regulatory body that was responsible for administering the program. And we invited them to our boardroom. We had them all around the table, and we said, this is a wonderful program, great initiative. And we talked about a process where we would help the government vet the quality of the applicants and ensure that they were able to select the very best candidates. And our thinking was, you're going to have a flood of people from all over the world wanting to get into this program. And the director general and the policy advisor, they kind of smiled at us and they said, guys, you don't get it. This is a low volume project. We're looking to get a few maybe iconic companies that could develop over time, but this is not what you think it is. It's not going to be high volume. And, in the first year, I think they had 2 or 3 applications, and we looked at each other after they left and said, wow, we really got that wrong. We thought this would be something quite different. Fast forward now, today, there's about 19,000 applications in queue, and it's exactly what we thought it is. It's been a huge demand all over the world, companies of all different sorts, and in fact, having some sort of integrity check and some qualifications in terms of weighing these candidates was exactly the right thinking. And I think that's where we're going to get to. The interesting prospect of SUV, when you look at the analysis of it, is that during the pandemic, when the borders were closed, it actually became even more popular. So we saw high volumes of individuals from around the world being very interested in Canada. Partly at that time, Canada had a fairly stable approach to managing the pandemic. And I think in other countries where there was deterioration, there was quite quite a bit of interest in just the stability that Canada brought. And what we noticed was a massive volume of applications coming in, even though the borders were closed. Now, at the same time, what happened in the market was that many of the entrepreneur streams and some of the processes that were available to come in if you were an owner or an operator, they closed. So many of the venues that were available for consideration were limited. And so what we noticed in the marketplace was that there was a real enthusiasm around the SUV program, but unfortunately, some of the designated entities and some third-party groups started getting more focused on making money than picking the right types of companies. So we saw a lot of artificial transactions being created and a lot of applications that were not genuine being produced, and that added to the volume. So you have this massive interest in Canada, then you've got this trend around some artificial transactions, you've got some good players in there as well. And then during this time, keep in mind, IRCC, all of their officers were working from home, and many of these applications were filed in paper. So they were building up this massive inventory. And then over time, IRCC, about a year and a half later, started developing an electronic processing approach, which makes sense. But there was quite a bit of inventory building and not enough processing. And that's why we have a very significant inventory that we'll talk about. We have a new minister now. At one point, Minister Fraser, the former immigration minister, was very active about opening up the SUV program. There was talks about an open work permit, maybe even a 3-year open work permit. But there is a new climate. If you've been watching in Canada, the doors for immigration are open. Our levels numbers over the next 3 years will be 485,000 up to 500,000 in the next 2 following years. So Canada's very much interested in looking for the right type of immigrants to help us economically. However, there's also a concern around housing and concern about whether or not bringing in high volumes of immigrants makes sense when we have some of these challenges. Interesting, provinces like Manitoba might be very interesting as an option because housing is a much more balanced. So, I think today's discussion is timely. But what you'd find is that now the discussion is about checks and balances and looking at our immigration policy and making sure that there is a balance. And so what we anticipate in the program is that there will be more interim checks and balances, and the reviews, as you will hear from both Alif and Pushkar, are becoming much more sophisticated. The questions are more thoughtful. Officers are understanding the nature of the concerns in the market. And so today what we'll bring to you is insights from the court, from our day-to-day processing, from letters called procedural fairness letters, where an officer is suggesting that you might be refused unless you can address concerns. We've taken all of that information. We're going to present it to you. And I think by the time you're done, you'll be in a really good position to know how to navigate this program for success. I have a chart, and you'll see it later, but it's quite interesting. It talks about the volume of cases that have been submitted. And you'll understand why we're in a situation where we're dealing with a growing inventory. In 2021, IRCC received 3,135 cases in the SUV program. In terms of the cases they were able to process, it was only 706. So you have almost 2,400 cases that did not get decided but were received in 2021. Those carry over to the next year, 2022. But on top of that, they received another 2,128 files. And of that number, they were only able to process 613. So like 25% roughly. And they still have to deal with the 2021 inventory. And then again, you would find this year, they have not yet been able to identify the number of files because they've not even opened them. And we're in the month of December. And they've processed, again, about 541. So it seems like they're getting through about 25% of the yearly amount of files that are received. and there is a surplus of previous years' files that get added on top. So clearly, this results in extended processing times, which is part of the reason why they introduced the option to get a work permit. And that allows startup visa holders or applicants to come in and start working on their business if they're urgently required, and these are typically for essential members, and Alif and Pushkar will work through the details with you. But it was a happy medium to allow people to actively work on their startup while their PR application is pending. And as a firm, we've spoken to the department that this is a story of, too much water going in the bathtub and not enough getting drained. And what happens if you don't drain and approve these applications at a good pace, eventually, it becomes messy because you just can't keep up with the demand. And we've seen this in other categories. So we'll talk to you at the end about what if some of the smart solutions might be to get in front of that. We'll share the deck again with you at the end of the session. But one of the points is we see people from Bangladesh. We see startup applicants from within Canada, China, Hong Kong, India, Iran, Pakistan, Russia, Vietnam, Turkey, the UAE, and many from the US. That H-1B issue is a real issue. And so you would see that we have a number of candidates from all over the world, very much focused. The other interesting observation is that the approval rates have dropped from year over year. So the demand is still high, but we see the approval rate in 2022 was 86%. And this year, we see it dropping by 26% to 60%. And we think this is a byproduct of officers becoming more savvy, understanding some of the concerns. They can use a process called peer review, which means they can have an incubator's due diligence checked by an expert group to see whether or not the right steps were taken. And I believe they're starting to see patterns of concern. So in our firm, we've seen procedural fairness letters where officers are asking very detailed questions about the innovation, about your technology, your IP in Canada. Have you created a website? They're really digging into the merits of, are you genuinely connected to the business? And so today, as we continue in the discussion, Alif and Pushkar, they're going to talk to you about some of these trends and what you should do, whether you're in the program today or whether you're thinking of coming into the program, to create your own due diligence to ensure you're successful. And I'll just, before I turn it over to my colleagues, if anyone's in the program and you feel, and we've had this discussion with other clients, very concerned that, oh no, I haven't done this. The beauty of these applications right now is it's taking so long for a decision to be made that you can always go and strengthen your application. And we've done that for many clients where we've made very robust additional submissions, and the officer has to look at all the information. So please don't worry. This is an opportunity to do things the right way. So I'm going to hand it over to Alif, and he's going to talk to you about the key eligibility and regulatory requirements. So over to you, Alif.
Thanks, Naman. And thank you to Nerman for the kind introduction as well. I just wanted to get a brief overview of the eligibility requirements for the SUV program, the regulatory requirements, as well as the policy guidelines. And so the eligibility requirements for this program are very straightforward. And that's part of why the program was so popular when it first came out. It's because it was very light. So there are 4 things that you want to look at. You need a commitment certificate or a letter of support from a designated organization. Part of this is a due diligence check which the designated entity performs. And it also names all of the essential members and founders of the company. And so it's very important that the commitment certificate is in line with everything that the business plan states, everything that the applicants intend on doing in Canada as well as the basis for the application. And that being the innovation, the product, the service, whatever the business is about, it has to be all inside the commitment certificate and letter of support. Another part of the requirement is the language test scores. So either the IELTS test or the CELPIP test. And it's a requirement to score a minimum of 5 in all 4 language skill areas. And these scores have to be valid at the time that you make your application. The next part is having a qualifying business. Under the regulations, a qualifying business is one that the applicant provides active and ongoing management from within Canada. An essential function of operations is conducted in Canada, and there's an ownership structure that has to be adhered to. The ownership structure demands that the applicant holds a minimum of 10% ownership in the company, and all of the founders have a joint combined ownership of more than 50%. The reasons that they do this is so that the essential members of the company hold the voting rights of the company, and they determine what happens with the company overall. If they have less than 50% and an outside investor holds more than 50, then it leaves room for the applicants to be ousted essentially by another outside organization that isn't part of the application. And so that's why IRCC and the regulations demand that there are certain ownership requirements that have to be met and maintained all the way until the application is approved. Another part is the incorporation of the company in Canada. And so there is not a requirement to immediately incorporate the company. Even if your application is close to being approved or finalized, there is still no requirement that the company is incorporated in Canada. But you do have to show an intent to incorporate. And part of that intention is also speaking to the commitment that you have to running your business in Canada and being a part of that business all the way up until your PR application is approved. Another part, and the final part, is the settlement funds. Settlement funds are any liquid cash or bank accounts, assets that you have that are unencumbered by any debts or obligations that you can show towards the required settlement funds to show for the PR application. And so those components all speak towards the eligibility requirements of the program. However, there are also a few different aspects and a few different things that I'll get into that should be shown to bolster and strengthen your case. This is just the minimum requirements that you need to be eligible for the program. Moving, yeah.
One comment. I think this is really important. These are critical areas. Without this, you're not eligible. But that first bullet point's really important. You have to receive a commitment certificate. But simply getting a commitment certificate from a designated entity in and of itself doesn't necessarily mean that you're going to be successful. It's really important that you interview and you understand the quality of the entity, right? There are many entities. There are incubators, there are angels, there are VCs, and you can get a letter, but the standard in terms of what is required to get a certificate will be based on the standard that's created by a particular entity. So what we've seen in the market is there are some designated entities where they'll issue a certificate to just about anyone, unfortunately, and they'll take the money, and that's the way they're doing business. But those same designated entities are starting to get a number of procedural fairness letters, and Pushkar will talk about this too. They're being sent to peer review. They're questions about whether they did their job properly. Did they actually do the due diligence, the way that they should, to ensure that there were checks and balances and thoroughness? So one of our points is not all certificates are equivalent. Make sure you pick a designated entity that has a good reputation, is very thorough. If they're giving you a hard time, that's a good thing. That means they care about their reputation and they're being selective. And so I just wanted to add that point, and I'll turn it back to you, Alif, to continue.
Perfect. Thank you, Noman. And Nermin, if we could just go to the next slide, I'll just discuss the implications of the SUV work permit, which Noman mentioned previously that these were created as an optional benefit to individuals who applied for their PR application, since the processing times were so significant. So essentially, instead of waiting for 3 years for your application to be approved, the IRCC implemented they implemented a closed SUV work permit for essential members to come to Canada and work for their specific startup company up until the date that their PR application is approved. This would ensure that while they work on their company, they can establish it and strengthen it and gain traction and revenue, so that when they do get approved for PR, their company is already ready to hit the ground running. And so it's essential that the commitment certificate names that all of the essential members in the certificate are required to come to Canada on an urgent basis. So there has to be an urgent business need for this work permit for each essential member. If the member is listed as non-essential, then there is no argument that can be made to provide them with a work permit, because they're not urgently needed in Canada and they can just wait until their PR application is approved. Part of this concern is the open work permits that were announced by the previous minister. He did address that there's usually a significant amount of time from when a startup company is established in Canada up until they actually gain traction and revenue. This could take anywhere between 1 year, 2 years, even 3 years. Some startups may get revenue right away, and they might be in a very good position and a very strong position almost immediately. But the reality with startups is that it's very fluid, right? It depends on what industry you're in. It depends on what your product is, what your innovation is. And so there's a few things that are to be considered when the minister, he made an announcement for open work permits. And one of those things was to address the fact that, there has to be some sort of traction in order to be living in Canada, right? So that was one of the reasons why he made that announcement. However, it was never really implemented into the regulations. And since then, the minister was shuffled into a different area. And so the new minister has not yet adopted this announcement into regulation. So currently we are not seeing any open work permits, and we do not foresee that these open work permits will be made available to SUV applicants. And that's mostly because of the level of commitment that you have to show to your SUV company, as well as the new compliance inspections that have been coming out. This kind of gives us some insight as to where this is headed in the program and why they're kind of shying away from open work permits and kind of emphasizing that active involvement in your startup company is what will be the new emphasis. And so we've seen that with the compliance inspections that have been issued recently. Speaking of active involvement in the startup company, this is important for a number of reasons. One is to keep your PR application alive and updated. So after about 1 year after submission, you'll receive a request from an IRCC officer asking you for updated information, as well as updated forms and documents like a police clearance certificate, proof of funds, and also business updates asking about how active you've been in your company. And so showing active involvement from the date that you submit your application up until the date that they ask for this information is very important, because if you cannot show the officer how involved and how active you've been in the company since you submitted your application, then the officer will most likely issue another procedural fairness letter asking even more details. And it's just not a very good way to ensure the strength of your application. So it is important to stay actively involved and to make sure that you can provide RCC with a very robust update when they do ask for this information. Another purpose behind showing active involvement is to show that your main intention in this program is to start a successful Canadian business and not primarily to gain an immigration benefit, right? So even though this is at its very core a PR application and a PR program, the way that you get that PR program is by establishing a successful company in Canada. So you can make sure that you doc all of your activities and document as much as possible so that you can show the officer that this is not just for immigration. I am committed to my business and I am committed to establishing its success in Canada. And if we just go to the next slide. I'd also like to talk about the commitment certificate and how it plays its role with all of the essential members listed within. All of the essential members in the certificate are in it together. This means that if an essential member is refused, then all of the essential members who also filed applications will be refused. So the failure of one application will kind of dictate how the rest of the applications will go. So everyone has to be approved in this program if you're listed as essential. And so we have seen in the past where a group of, let's say, 4 essential members have all submitted applications for PR, and then maybe one person previously applied for another PR program, or even after they applied for another PR program. And it turns out that that separate PR program was approved. What happened in this scenario is the IRCC will withdraw the pending SUV PR application, and they'll approve the one that was recently submitted or previously submitted. And in effect, what happens is IRCC withdraws all of the, sorry, not all of them. IRCC will withdraw the PR application that was pending, and as a result, it will refuse the other essential members who are still waiting for a decision. And so there's a lot of implications that you have to think about when you're adding an essential member to the certificate, or if you maybe perhaps want to leave someone off of the certificate. Maybe they're not as essential, maybe their role isn't as important in Canada, but that's something to consider when you're making, when you're working with the designated entity to create your letter of support and build your team. That's also something in regard to the work permit that should also be considered. Is this person urgently required in Canada, or can their function be performed while they're working in their country of origin or wherever they're residing at the time? If they're needed in Canada, then they should be listed as essential. And there should be very detailed language in the commitment certificate as to what they will be doing in Canada, what their experience is, how they will perform their job, any qualification like education that they have. All of that information should be present, and it should form a basis for why they should get the work permit. And so that's all part of the commitment certificate and the letter of support. Officers also ask a lot of questions in procedural fairness letters. And these are generally issued after a year goes by and the officer has already received updated information from you, and they've assessed that information and they have some follow-up questions, or they might have concerns that maybe the business isn't, there's no active involvement in the business, for example. And so they start asking a list of anywhere between 15 to 20 questions that are specific to the business. Things such as, have you generated revenue? Have you done any market research since you've arrived in Canada? What kind of traction or revenue do you anticipate in the next year? Have you hired an accountant? It can be various things that generally a business should look towards doing when they're first in Canada. And so a stage after that is peer review. And Pushkar will get into this in greater detail because there's some case law around it as well. But essentially, peer review is where an officer refers the case to a panel of industry experts because they may have concerns about how the due diligence was performed, and they seek an opinion from this peer panel. And the applicant doesn't get involved at this stage, but it's mostly between the officer and this panel of industry experts. And the officer receives a recommendation from this panel as to what kind of due diligence was performed, and the officer can use this information to make a final determination on the file. And if we can just go to the next slide. Okay. Now we'll move on to best practices and common mistakes that we often see in SUV and permanent work permit and permanent residence applications. Something that we are very big on in our firm is perfecting the application. We want to ensure that the best possible and strongest application is put forward. The reason being is that we also see a lot of individuals come to us who may have filed on their own, and there's a lot of missing information that the officer does not have when he's assessing the application. So one issue that I see with IRCC's document checklist is that it does provide the bare minimum that you need in order to be eligible for the program and just to have your application assessed. That doesn't necessarily mean that your application is complete. Complete in the sense that giving the officer a complete picture of your business, a complete picture of your pitch deck, your plans for Canada, as well as your innovation and your technology, whatever it may be. The real core of your business is often missing if you didn't submit it at the very beginning in a complete manner. So we like to go way beyond the document checklist because it's very bare bones for what they have. And so we include pitch decks, business plans, qualifications of all members, including education certificates, experience letters if available, as well as any other information that we can provide in regard to the benefits that this startup company will provide to Canada. Benefits to Canada can be anything from the innovation of their product or their service and how it will make Canada competitive on the national marketplace, or even within Canada, if it just promotes a certain industry and tries to innovate a certain industry. We've also seen that in the past. And so it's very important that we convey the benefits to Canada in the submission letter, and so that the officer has a very good understanding of what this company is about, what benefits they'll provide, what the innovation is, as well as what the individual founders will contribute towards reaching these goals. And so we like to partner with our applicants and our clients to draft the strongest case possible. We rely on the designated entity for their commitment certificate and the information that they've gathered during their due diligence check. But it's also important that you work with the client and the applicant to make sure that you really showcase their vision and their plan for success in Canada, and that you convey it to the officer in a manner that's effective, efficient, right to the point, but also can show the officer that this company is great, this is what they will provide to Canada, and this is why their application should be approved.
Something add one comment. It's a really important point that you made, right? This is probably the most critical phase of setting the stage right for success, is getting all of that information. And it's basically like you're pitching to an investor, but it's IRCC. And the test is, am I genuine? Am I truly committed? And have I explained the spirit of the program through the information? And I'll tell you, we were shocked sometimes because we'd get an emergency retainer, and we would be advised that someone had filed the application themselves, or even in some instances with a law firm or a consultant. And when we looked at the application, it was no more than 4 pages. And it had, the language test was part of that. The forms were complete, the certificate, a letter of support. But there was no description of how this business was going to work, or how the individuals who were taking roles were well qualified to do that, or what the innovation was. So in the typical application we put together, it could be 80 to 100 pages of rich information to make the case. And just think psychologically, right? If an officer looks at a case that's been prepared this way and they're reviewing it, and then they open an envelope where you've got 4 or 5 pages, the officer doesn't have a fair perspective to be able to make a positive decision. So what do? They ask, like 40 or 50 or 60 very detailed questions. And now you've got 30 days to respond in some instances to that. And you can't redo history, right? So what we try to do is set the stage in a very robust way, but then you'll see we actually have an activity tracker where that's the beginning of your journey. And now you continue to drive forward, record information to make your case. So good, that's a really good point, Alif. And I think that's one of the messages we want to give out to anyone. If you filed and you didn't understand that there was more to it, we can talk and fix that, but don't leave it alone. That's the core of what this program is all about.
Yeah, thanks so much. And yeah, some of these success stories that we'll share later do include a lot of these kind of applications where an applicant filed on their own and they've received this PFL, they're close to refusal, and we were able to successfully intervene and kind of go on record with all of this information that we just mentioned, and we got them a favorable response. So that's something that comes up quite often. So it is a good thing that you can always kind of intervene and kind of go on record with IRCC, but it is definitely a good idea not to wait around and just kind of leave it with IRCC and let them process. So it is a good idea. Just always keep updating. And that's something that the activity tracker, which I'll get into next, is very important. One thing I did want to comment about is the work permit considerations as well. It does come up quite often with our clients as to how much time I should be spending on the work permit within Canada. Is it going to affect my application if I'm outside of the country for a prolonged period of time, or do I have to be in Canada for the entire duration until the permanent residence application is approved? And the answer is you do not have to remain in Canada for the entire time until your permanent residence application is approved, but you should always be showing the officer that you're actively involved in the company and you're always doing these business activities and you're always trying to establish and further your business, even if you're outside of Canada. So if you spend, let's say, 6 months out of the country, but you're actively involved in the business and you're doing everything you can from outside of Canada, it's very important at that point that you document everything and you make very detailed notes of everything that you're doing outside of Canada, just to make sure that the officer knows that you're still actively involved. While you're in Canada, it is also very important that you use your time very wisely, because if you plan on being in Canada for, let's say, 3 months, and then you plan to go back home and then come back, there's some travel involved. Those 3 months that you spend in Canada is also very important. And you should be able to document as much as possible and really try to make best use of that time. We have seen work permit refusals in the past, things anywhere between lack of proof of funds, for example, or maybe the officer just put some very vague and generic language in the refusal letter. This does happen sometimes because sometimes the officer just doesn't quite understand the program. There is some officer training that I think now is probably being done because of these compliance inspections we're seeing. But I think in the past, officers weren't as well versed with the program and the program requirements as they are now. So we are seeing less refusals, thankfully, but it is still a possibility that an officer will make the wrong decision. And so what we've done in the past is we've layered in our own language that addresses regulation, case law, and other guidance and other information that we've found to layer it into our submission letter so that we address these issues and these previous refusal reasons that an officer may have had in a different application. And we preemptively try to get in front of it and answer any questions that officers may have before they even ask it. So we really try to perfect our submission letter and perfect our application by addressing any previous refusal reasons that we've received in the past. And so that's kind of been our practice moving forward, and I think it's worked fairly well in recent months. Now, if we go to the next slide, the SUV activity tracker, which I'll get into the slide after this, is very important because it provides the officer with a frequent update on what's happening with your business. And again, this is a very important theme of our presentation, is active involvement in the business. So as long as you make a good practice of maybe weekly or daily submissions into some sort of activity tracker to document what you've done, when you did it, what the result is, what the target is, maybe any kind of information that you can show that you're actively involved in the business is very helpful. So if we go to the next slide, I'll actually show you a sample of our own activity tracker that we provide to our clients. And so this list of activities right in the center, it's from a drop-down menu that we've created based off of previous PFLs, previous request letters that we've received from IRCC. And so we've been adding to this library of activities that officers specifically have asked for in previous applications and previous request letters. And so it's very important that we kind of weave in this information in our submission letters, as well as pay close attention to what the applicant is doing. And if they are maybe lacking in one area that we see officers ask a lot of questions about, then it would kind of point your attention towards maybe performing those activities or completing those activities based off of this working and live list. And if we
Just
go to the,
one comment,
yeah, go
Alif.
ahead.
You know, the value of this tracker too is that, as you'll see when Pushkar speaks, when we see a trend in case law that an officer has decided that a certain factor is critical, or when we get another procedural fairness letter and we see that the officers for a certain type of business are now asking 5 questions that are coming up regularly, it automatically, we go into the tracker and add those drop downs. So it's like a real-time way to gauge what's happening in the program and keep our clients, back to the theme of this presentation, a few steps ahead, because you want to be thinking about what those trends are. And it forces, again, that engagement of being active in your business, taking action, moving forward. So again, this has been helpful for us. We were always concerned when we file the application, everything is strong, but what happens in 3 years, there's a lot that can happen. And this enforces engagement of the individual. So, we've got a lot of good feedback, and we highly recommend having a process like this if you're going to be in the program.
Yeah, thanks, Suman. And if we go to the next slide, which I think is my last slide, this is just another overview of the activity tracker, how important it is that you document everything that you do, remain actively involved in the business, and still be able to show it as well when the officer asks. And so, again, the activity tracker that we have is based on frequently asked questions from IRCC officers. And so this is our preemptive strategy of getting in front of it and hopefully answering any questions the officer has before they issue a request letter or a procedural fairness letter. And that being said, I think I'll hand it over to Pushkar now, who will talk more about procedural fairness letters as well as relevant case law that's out there currently for the startup business class.
Perfect. Thank you, Alif. I think the regulations, you've explained them in depth, and they all intertwined with the federal court cases. So I'm going to begin with this case, Buey versus Canada. This is one of the early cases which laid down the foundation for the upcoming cases that we are going to be talking about. That is 2022 and 23. So all of these case law are with respect to either permanent or work permit application. So it's permanent residency application under the startup visa program, or the optional work permit that some applicants activate to start working on their business while the permanent resident application is pending. In this case, the court defined what a peer review is. So drawing from what Alif mentioned earlier, there are two important aspects of a peer review panel. All right. The first is to check whether there's fraud happening within the designated entity and the applicant, right? Whether there are fictitious businesses which are being created and a letter of supports or commitment certificates are being handed out by way of paying for them. That's one. The other is it is also has an inbuilt mechanism to check whether the designated entity, the incubator, the angel, or the venture capital, whether they performed due diligence before supporting the business proposal of an applicant. So if you are an applicant and you have a business proposal, uh, each designated organization has their own process. It's not laid down under the regulations that this is the process that you have to follow. So a peer review panel essentially checks whether due process was followed or whether there's any fraud. So that's what the court said in this case. Uh, Another very important factor in the peer review process, the applicant does not necessarily participate. It is between the designated entity, the officer, and the peers. So the applicant cannot come and attend and make arguments, either oral or written, to say that these are the reasons and this is the information I provided. It is the designated entity which is to provide explanation as to their process that they followed while vetting the applications, such as looking at the business, the prospects of the marketplace in Canada, among others. Further, yeah, it's a very important one. If the applicant is asking for the optional work permit, then it is important that not only the letter of support, but the submission that you are carving out to the officer explains your urgency. So the court held just because it is mentioned in the letter of support does not in itself create that a substantial tie. You have to go a step beyond. Um, Further, and of course, this is one of the most important parts of the startup visa application. That is, there is a fine line between participating under the startup visa program to acquire privilege, that is, gaining permanent residency, and to start a business. And you have to ensure that you stay above that fine line. That is, your intention, your first and primary intention has to be that you want to establish a business, and that is being supported by a designated entity. And in support of that, as a benefit, you are availing the permanent residency status. That is most important. Can we go on to the next slide, please? Okay. Serembetov versus Canada is a landmark judgment in startup visa work permit applications. The the principles that are laid down here will be definite. I've been reading through the questions that a lot of the participants have asked, and I think a lot of those questions will be answered by this case law. So it and the court, of course, Justice Diner, who's a very reputed judge in the federal court, and he explains what is the purpose of the startup visa program. So he goes into the depth. He interprets and explains that the startup visa program is primarily a program where you gain permanent residency in lieu of establishing a business, right? The work permit is an optional component to it. When it was initially established, the work permit was not even there. It came in later by way of ministerial instructions. So if an application for work permit has been filed under the startup visa program by following due process, then the application cannot be refused on the fact that this applicant will not go back after completion of the work, or the applicant has family ties, or the purpose of visit does not make sense. And the court beautifully articulates that the startup visa business class program is a classic example of dual intent. That means, although the application is for permanent residence, the applicant wants to enter Canada temporarily to start working on the business to ensure that by the time the permanent residence application is processed or granted, the business starts, and to meet certain milestones that Alif and Noman discussed with respect to the business plan. Let's go on to the next slide. There's a lot of more that happened with this case. Again, reiterating that the program is designed to be a temporary work visa, but is not designed to be a temporary work visa, but a pathway and a step to facilitate the permanent residence, right? And a very important principle was carved out with respect to language tests, which I'm sure a lot of participants will be interested in hearing. So under the startup visa program, you have to show that you have a level of English proficiency, right? That is CLB 5, and in fact, you have to have 5 in all 4 languages. This court held in this case that the language proficiency does not need to be shown while applying for the work permit. So this was a landmark decision in terms of the applications which were being refused because of the fact that because the work permit application did not have IELTS test scores, right? Now there is uh, the regulations have since been updated in May 2023, which now require one to provide the language test. But again, it is arguable whether it is a requirement under the regulation or is it just instruction to the officer to assess. Let's go on to the next slide. Well, a very important part, and carefully understand how the court we did this inside the program. The court says that this program is to start a business with an innovative idea. It does not necessarily have to be for a world renowned expert coming to lend their names to institutions or businesses or entertainment productions or academia. So you can be a normal person who has a great idea with the eligibility criteria and with and are able to meet certain requirements, and that can be sufficient. You do not have to have a world renowned expert who is applying under this program. Another very important aspect with respect to incorporation of businesses. So the court also held that you necessarily do not need to incorporate a business before applying for the work permit. You can incorporate that business after you land in Canada. So that's another important aspect, and I think I saw a question there in the board. And of course, the fact that a peer review process is not mandatory. The officer at its own discretion may request for it if they require. So this in fact laid down a number and series of issues, and this has been followed in further cases also, such as the one that is mentioned on this slide, the last bullet point, Azizi v Canada, which incorporated a lot of the guidelines laid down by Justice Diner and Serembetov. Let's move on to the next slide. Okay, this is a very important case, because this question comes up in many of our consultations, and Alif and Noman can add to this. Uh, the underlying the underlying meaning of the program under the regulations is that you have to start a business. All right, you cannot join an existing business which is already functioning and already has certain groundwork that has been already done. This also goes to the root of certain concerns of matching between applicants. So it needs to be that one person or a group of people, three, four, five, are coming together to start a new business and getting their experiences and joining that together to contribute to that business. That's a very important aspect. The other part of it is that this also decided and discussed what a peer review process is, and which we've already discussed, that it is to check whether the due diligence was performed by the designated entity. All right, and of course it is not a way to check the worthiness of the business. So it is, the peer review process does not check whether the business is viable. The peer review process checks whether the designated entity performed due diligence when it was granting that support to the applicant based on the business documents that they provided. All right, maybe we can go on to the next slide. Okay, another interesting bit. Uh, so in this case, the court held that the designated entity's assessment of the business, right, particularly the rationale with respect to the urgency of the applicant to be in Canada, is not something that the officer has to particularly rely on. The officer can make up their own mind. So a letter of support or appointment certificate mentions, there is a place where it mentions under a clause that this is the urgency based on which the applicant needs to be in Canada. Therefore, and based on that, the applicant applies for a work permit after submitting the permanent residence application. So it was argued in this case that because the designated entity has already mentioned that this is the urgency, the officer cannot frame up their own mind. The court held no. The officer has the discretion to go beyond the designated entity's assessment and make up their own mind with respect to whether it is important for the applicant to be in Canada or not. That permit. Also, to go a step further, the court also, and this was not, and the following was not the ratio of the judgment, but it was incorporation of the respondents, the department's arguments, wherein it was held that the peer review process applies only to the permanent resident application and not the temporary work, which is optional in nature. Maybe we can go on to the next slide. Okay, I believe that this is one of the foundational cases with respect to procedural fairness that Alif briefly discussed. So, in this case, what transpired is that the after the application was filed, the officer went onto Google and ran a search with respect to the business. And this business was a software which the applicants intended to incorporate in Canada and then work the North American market, right? Among other countries. So the officer went on to Google and did a small check and found out that there are similar softwares available, and figured that this is not probably the best or the most unique business to be established in Canada, right? As the court held that the officer made a grave error in not presenting this to the applicant. So if there is a Google search that the officer does, or if anything that is not a part of the application that we submit before the officer, and it is dehoards the application material, a Google search, anything else, the officer must put their concerns to the applicant and provide them with a fair opportunity to respond to those concerns. So the court held that this evidence should have been presented to the applicant, and only after that, after hearing the applicant and letting them respond to the concerns, the officer should have passed an order. So this is what procedural fairness in its true sense means: the constant adequate communication, all right, providing an opportunity and a fair and transparent process. So these are, few things that we derive from the federal court cases, and we use these principles in our applications. And the next case on the next slide discusses another very important principle, and this will go to the root of the SUV files, and it will also touch base upon how we do our filings and how we maintain and update and advise clients to maintain the activity tracker, and how we've been successful before the IRCC under the startup visa program. So in this case, the applicant effectively argued that the officer's analysis of the business, based on the business plan, the activities, etc., were not correct. The applicant said that I provided a complete application. I gave a business plan, I gave a pitch deck, I had all my evidences on point. But the officer held this that this is an artificial transaction within the meaning of Section 89, which effectively means that the business is being incorporated only to get permanent residency, and the applicants are not really serious about the business. The court then checked and evaluated these things, and these are very important. It's been reiterated for a reason. I'm going to read out and point out the important aspects from this. The court looked into the business plan and said that the business plan never identified what the product would be in its true sense, how it was created, and what was the unique features about the product. So those are very important aspects to mention in your application. There was no evidence that it could generate revenue. So you need to explain what is the financial roadmap ahead. How do you project that this business is going to make money? Uh, Further, that what are the costs that are associated with it? And what are the steps? And of course, went down to look into the manufacturing process of that particular product. And again, a beautiful articulation. The court says that this was an idea which was not fleshed out. So it is very important that you explain your business from the beginning, from the threshold to the end, and not only the business plan and the pitch deck and just the LOS, but your submissions should be on point, and your activities should explain what and how the business is progressing. That's the bit about the federal court litigation and the considerations that we've gained, and this is some knowledge that we wanted to give to you. I'll hand it over to Noman to take it to the next stage.
Sure. And I'll move at a slightly higher pace. I know it's great discussion, great job by Pushkar and Alif. I think it's a nice intersection of preparing and understanding the future of the program and how we interact and integrate that. The other piece, which was eye-opening to us last week, was the new SUV employer compliance inspections are starting. So it's exactly what you would think. You have now filed an application, you've put an offer into the IRCC system, and you've also incorporated. And what IRCC is doing now is they're triggering these compliance reviews roughly 20 months after the incorporation, after you filed your electronic offer. You're going to be, asked about your activities. Have you been actively engaged in the business in respect of the offer you put forward? Are you doing what you said you were doing? And they will come and ask in first through documentation, a series of questions will come to you asking for evidence to support that you are in fact actively engaged. And this is important because this falls under an employer compliance model, which was developed to identify companies who are not doing what they said they were doing or were abusing the immigration program. If we go to the next slide, I'll show you what you can expect when you do get one of those requests. It could be a review for your incorporation documents. Did you in fact incorporate? Business licenses, your tax documentation, your financial statements. If you are providing services or goods, show us that you have those invoices that have been issued by clients. Show us bills paid by the company. Show us your lease agreements. Do you have a place where you're doing business? And then any other information to demonstrate active involvement, which includes, as we've just, Pushkar had mentioned, they can go and start looking publicly to see what's out there about you. Are you doing something other than what you said? Are you doing another business? Are you, is there any activity about what you've been doing in your time in Canada that contradicts what you suggested? And so under this program, if you're found non-compliant, first of all, you get it similar to a procedural fairness letter, you get a heads up that they're leaning towards this. You can then try to justify. If you're non-compliant, there's a number of justification provisions. One of them is like a turn in the economy. So perhaps you were here in Canada, you had your best efforts in mind, but because of the turn in the economy, you were slower than you expected because you didn't have enough of the basic revenue to get going. You might be able to explain it. Again, at this point, when you get one of these notices, you should get advice because it's quite serious. Depending on whether they accept any of your justifications, they can issue a warning, a fine, or theoretically they can bar you from coming to Canada. So very serious implications. And it's more serious for an SUV applicant. For some of our corporations, if they get fined, they pay the fine, they correct their process, they're not happy, but the corporation continues. But for an SUV applicant, if there's a negative finding that goes on your record, when it goes to the PR determination, the officer will be aware that their colleague has determined that you are not actively involved. Goes back to this question that Pushkar touched on, is what was the intent if the person wasn't actively involved? Was this an artificial transaction? Was it someone who was in a matching scenario who's just trying to ride the wave to get PR? This is what comes up. And I think this is a good initiation by the government because they're trying to separate the genuine from the non-genuine. So get ready, expect that, particularly between 15 to 20 months. That's when you might be selected. And this is how you need to respond. Maybe we can just go to the next slide and we'll move into the wind up. What we thought we would share with you, and we'll keep it quick, is some success stories that we've seen in terms of our involvement in the program or with companies. And then we'll give you a little flavor of what we think the future of this SUV program is. And then we look forward to questions and interacting with you. So Alif or Pushkar, whoever wants to kick it off with sort of a short nugget on one of your highlights.
Sure, I'll start. I mean, there have been plenty of highlights, a lot of like great businesses that we interact with daily, but the few that stand out to me is applicants who may have filed on their own or with the help of someone else, maybe an agency or whoever it may be, and they receive a PFL and they respond to it. There's some back and forth between the client and the IRCC officer, and they receive a final PFL asking a bunch of questions about the business. And then we get contacted by the client and he says, look, I've been actively involved in my business for the past 2.5 years. I have like good revenue, I have good traction, but the officer is still issuing a PFL for me and I'm not sure what to do at this stage. And so we get contacted at the 11th hour, which is not something that we typically enjoy doing, but we do like a challenge, and I think we overcame it pretty well by submitting our own application. And we also worked with the client, and we got a very record detail of everything that he's done. And so we presented it to the officer in a way where he could kind of go line by line and see that this person has been actively involved. This is where the business was at the initial stage when they first submitted their application, and this is where they are now. And so we really showed the officer everything that we possibly could with the help of the applicant too. And in the end, we ended up getting a favorable response. And so I think that was a very good success story. And we've had a few of those in the past as well. And I think those are the ones that I personally appreciate the most because it's such a quick turnaround, but also we save the application from who knows what could have happened after that, right? So I think that was something that stood out to me.
I'll I'll draw further to the same story. So if in case Alif, Noman, if we weren't engaged, because I've been on the other side of this. So in the beginning of this year, we were engaged with a group of 10 SUV applications. So all of them different businesses, all of them from Iran, and all of them applied under the startup visa program, the optional work permit. All these applications were refused with similar reasons, family ties, the you will not go back, the purpose of visit is not relevant, and also there was a provision cited C10 instead of the startup visa. And I think that this was probably one of the fastest resolutions that we were able to obtain in the federal court, which usually takes a substantial amount of time. We were able to settle all of these together, group them together, and settle before the federal court, wherein the department consented, based on the findings of the federal court in the case law that I mentioned, Serembetov and a couple of others. So we used that to challenge it before the court. We reached out to the department, we reached out to the IRCC, made several series of recommendations saying that this is what is coming out of this visa office. And we are given to understand this was not only the group, these 10 groups were not only the one, there were more who were being refused based on an erroneous understanding of what a startup visa is. So we at times also take the liberty to explain to the officers of how they should process the application, wherein we educate them by way of providing regulation, instructions, and also what the court is saying. So that's something that has been a success for us.
Great. And I'll add, for me, what gets me really excited is, as a proud Canadian, when I see opportunities south of the border and we get to take advantage of them. We had an individual, 21 years old, student in the US, really smart in AI. Not only was he, actively studying in a top university, but always thinking about services and innovation. And he came up with a great idea. We got a call that this individual just received $3 million of funding from the same VC that funded ApplyBoard, and that the CEO of ApplyBoard is actually watching this company. We talked, all three of us actually got on the call. We talked to him. He's like just slightly older than my son, who just plays video games all day. And this guy is like $3 million of funding, thinking about the next generation of AI. We worked really aggressively with the VC. We got his application filed. We highlighted the important value that he could be a game changer, and he received his work permit in 6 weeks. He's in Canada now and potentially going to hire 10 like senior roles in AI, which is just amazing. And the US, they're limited in their immigration system. So there's a lot of opportunity south of the border. Some other amazing companies. We had one that 5 Indian students, they were all about 23, 24, using 3D printers to create the actual heart organs for pediatric surgery. That was tested in the market. They're coming to Canada. They're going to use that same thinking to figure out how to prevent unnecessary surgeries, make sure that Canadians and other individuals get better treatment and healthcare. Again, just amazing innovation and talent. And so that's what gets us excited, is every day we talk to individuals who are really passionate, really determined, and they have an idea and they work hard and they get there, right? And one of our recent clients, he's knocked out of the SUV program, and we're happy. And it's a good story. He got knocked out because a third-party investor saw what he was doing in Canada and was so excited. He made an offer that he couldn't refuse, and took his shares, left him with 2%, but made him a very rich person. And then we put him into another program, and we took care of the rest of the teammates. But that's what this is about. It's about trying to achieve success for Canada, for yourself. And that's what really sort of gets us excited. We think it's a great program in theory. It's evolving. We do have 4 policy papers with the government. We think that they do have to look at the risk assessment more carefully. We don't think people, like the federal court has suggested, that people are not actively involved who are riding the backs of another a worker. That doesn't make sense. We have to find that, identify, and sort of deal with it. And we do have a backlog because there's so much interest. So I think it is important to start thinking about a selection criteria where maybe those SUVs that are prime to take off because of what they've accomplished. Perhaps they should be looked at earlier, maybe fast-tracked for PR. Let the ones who are developing get the work permit and develop, right? Give them a fair chance. And then weed out the ones where there's bad actors, and compliance is really good. Designated entities, angels, VCs should be held to a standard to make sure there's integrity. And I think these random compliance reviews are excellent. It will separate those who are just trying to ride the visa from those who are really committed. So I'd like to thank my colleagues. I think this was an interesting discussion. We're very passionate. We're very deeply involved in it. And Nermeen, we'd like to turn it back to you and leave it open for discussion.
Thank you very, very much for this amazing discussion. It was really engaging, and I have lots of questions for myself as well. So I will start with, because we have now lots of questions in the Q&A, and I have my own question that I get from either from my personal, connections, or questions that I get through the process of processing and evaluating the startups. So let me start with the first question. So a question came saying, can we work for other companies on the work permit? I believe they changed some rules recently and disallowed, earlier it was allowed. Also, the duration of the work permit, is it changed from the 3 to 1 year? So I think that they are asking about, did it already happening? Is it happening, the 3 years open work permit?
No, currently you're still entitled to a 1-year closed work permit. The previous minister, Sean Fraser, publicly stated that he was going to introduce 3-year open work permits. And as Alif mentioned, he wanted to give some relief to startups where they had flexibility. And if they were in Canada, they could work part-time, right? And still sort of move forward, because 3 years is a long time to be working on a startup, and startups have ups and downs. We're conservative. Like, our view, that rule did not get implemented. And typically, especially if you're essential, you should be actively, as you've seen the theme, is actively working to make your business happen. If you go and you start working for Walmart or IBM or someone else, and the officer is aware of it, naturally they would say, well, did you really want to work on your SUV, or were you looking to just enter the labor market? So our advice is, work exclusively, focus on your application, and we anticipate it will continue with closed work permits 1 year at a time. I did notice a question too. You can renew these work permits. So you can constantly renew until your PR application is adjudicated. You just must continue to show that you're actively working in your business, meet your settlement funds, and then you can move forward from there.
Interesting. And when you're saying that they can extend, is there like certain standards, certain, requirements or eligibility for anyone to extend the work permit, or it is something granted? So if you are coming through the SUV program, granted this first year, and you're still working and actively working, so it's going to be guaranteed that you're going to have the extension? Is this anything around this?
So we'll do the lawyer thing. So it's actually a new application, a new officer looking at it. Practically, if everything remains the same and they've been actively working, then there's no reason that it shouldn't be renewed. Now, you always have to be concerned if circumstances change. Sometimes what we notice is that they're no longer in that business, or something significant has changed, a material change. Or they could have an inadmissibility issue. We recently had someone that had a very serious criminal issue happen in Canada. So those are the types of issues that could be a wrinkle. But otherwise, if everything remains on course, these are issued as a matter of quite regular processing.
Interesting.
Yeah, and if I may add, Naman, we've been applying for a lot of work permit extensions, and we see this also as an opportunity to provide IRCC with an update, because the basis for the extension is that they're continuing to work on their business, and that their presence in Canada, their extended presence, is still required, right? So we still submit the regular application that we do, but we also provide an update. And that same update, we also attach it to the PR application, so that the officer, even though it hasn't been the full 3 years, it's maybe 1 year down the line after they get their work permit, we can still talk to the officer and have that open discussion about the updates that they have with the business. So it's kind of like you're tackling two birds with one stone. You get your extended work permit, but you're also going on record and providing the officer with a preemptive update before he asks you a bunch of questions on the permanent residence application.
Interesting. So the second question is related to the proof of funds. So they're asking, is it necessary to show funds for supporting the startup? I heard you have to show around 100,000 K or 150,000 for supporting the startup. So what do you think?
Yes, you need to show proof of funds, and that depends on the size of your family, and depending upon the number of weeks. Usually, it is 52 weeks. So, if your size of family is say four, then accordingly you just multiply it by the number of years that you intend to apply for. Initially, you'll of course do it for a year, but you need to project for the coming 2 3 years as well. So, ideally, you should be showing that much funds, but again, it varies on the size of the family. And at times also, there's since you asked that question, it's very interesting. uh, Not only proof of funds to support your family, but to also show investment funds. So it's been bifurcated in May 2023. There's by the ministerial instructions, there is a new threshold. So you divide it into your proof of funds to support your family, your children, and also to invest. So you need to show a bifurcation between those two if it is a part of your business.
Interesting. So I have a question of mine now that I want to just like embed it into the question, because my question is going to Pushkar. In your presentation, you were saying that one of your cases was related to that business idea was already replicated in other countries. I just want to discuss with you this specific point. So I'm a serial entrepreneur for 13, maybe 15 years. And I can tell you that there's no uniqueness anymore. In
Hmm.
every startup that I have seen it before in part of this world. And I have worked in many countries in this world. And I am very well informed about the entrepreneurial ecosystem worldwide, not only in Canada or my only on my. So how do you defend that? So there is no uniqueness. I'm telling you, there is no uniqueness anymore. Even rockets, by the way, it's not unique anymore. So even if I get a startup that is creating a rocket, I am not going to be amazed. It's already there. So how do you
Very,
defend this?
very interesting question. And coming from an expert like you, I think that's where we differentiate between what is unique and what is something that we can submit to be unique, right? So as you've mentioned, that there is nothing unique. Maybe once in a while you come across something like a Bitcoin, which is new, right? But then there are following stages to it, wherein there are replications. It is something unique in the same segment. So you may say that. However, you need to differentiate, and there's a case law to this. All right, a designated entity granted letter of support to two businesses which said that we were unique. One was, and this is sort of funny, but one was for tracking pets. So it was sort of a tracking device that you put on your pets so that you're able to, follow them. The other was for elders, to make sure that if there is some disease or people who are suffering from any ailment, they are able to detect this. So one designated entity granted the letter of support to both these, and both of them filed it simultaneously.
Hmm.
One was processed, but the other was caught, saying that this is the level of check, right? So the officer looked into it and checked and said, hey, I think that I've seen a similar business, and it doesn't have to be unique, but at least give me something more. Don't make it completely unique, but differentiate between what that business is and what this business is. Maybe that is the factor. Maybe that is what you need to explain. If there is no uniqueness, then maybe an innovation within something which has already been invented. I hope I
Okay.
was able to clarify.
Yeah, for sure. Okay, going back to the questions on the Q&A. So they're asking you, since the permanent residency processing time is 37 months, what do you with just 1 year of work permit? Oh, I understand. What to do after the 1 year? So he's saying, yeah, the meaning is that 1 year is not sufficient if you are coming, for example, in an idea stage or maybe a simple MVP. And I'm telling you, as a new immigrant, I believe that this is a very valid question because it took me 1 year just to settle myself and my kids. and then I will start to do my own plan as a parent, right? So his question is really valid. So how do you answer this?
If no one else is taking it, I can. But
Go for
okay, sure. So essentially, what you need to be showing is progress. The progress should be related to your business plan, the milestones that you've carved out in your business plan. If your business plan says in the first quarter upon moving to Canada, I am going to incorporate, then you must incorporate. If your business plan shows that in the second quarter of moving into Canada, I will get an office space on lease, you must get that. All right. And the realities of a startup are very clear even to the officers and to the makers of this particular provision. The legislatures also knew that this may take time and this may fail, which I'm sure is a question that will come subsequently, whether the startup is working properly or not. So they understand. All you need to be showing is progress. The progress doesn't have to be substantial. You are not expected to become billionaires overnight. Your company is not expected to be a unicorn. Your company is expected to take steps to progress. So that's all. So the first year, if you have substantial progress, good. If a little bit, even that is good. And then you renew and then further and further till your application reaches the stage of permanent residency.
Interesting.
Yeah, and to add to that, just in regard to the business plan and the commitments within it, it's also good practice to continuously update the business plan. It doesn't have to be yearly; it could be monthly. I would say, just based on how much you've done and how much you anticipate you'll be able to do, based on your restrictions and whatever else you have going on with the business. So within 1 year, obviously IRCC, they are looking at what you've submitted. So they are looking at what you've committed to be doing in the first year. And so if you see that maybe you're not quite reaching your goals for the first year, update your business plan. Update your business plan, provide the officer with an update, and then you can say, whatever I couldn't establish this year, I'll be moving it to the next year, and then I'll be doing something else, or maybe I'll switch directions a little bit, as long as you're making it known to the officer what your plans are and what your intention is. And this is also good to communicate with your designated entity as well, because there might be a time where maybe you've shifted positions a little bit and you might require a new certificate, right? If the change is substantial, then it might be worth revisiting your certificate and working with the designated entity there too.
Interesting. So when you say, Alif, that they have to update the officer with their business plan, so you mean that I'm an applicant and I went to and applied my work permit and PR, and then now I have a really great progress in my business plan. What should I do? Should I go by myself and send it to the IRC? Is this a process, or I go to the immigration firm and then I will share my case with them and they will apply it? So what is the case around how do I update the IRCC?
So typically, all the updates, if there's no request letter issued by IRCC, if you just want to go on record and provide an update to the officer, you can submit a web form. You can submit a web form request, and you can include all supporting documents. You can include a description of what you're submitting and the reasons why. As long as you have an application number and a UCI, it'll go straight to the processing office, and it'll be attached to your application. So that's the method in which you would update an IRCC officer if you don't already have an outstanding request letter.
Interesting. Interesting. That's clear. Okay, so I have a question also from my side. Is that what if you're in the business field, business may work and may not? Okay, so I started a business and I applied and I was 100% it's working. And guess what? Maybe it's 100% working in my home country. I came to Canada and boom, it didn't work. So, but I'm serious and I have spent lots of money. So there is the pivoting thing. So now I wanted to pivot. I'm doing software that is, for example, again, maybe Pushkar's example. I started my business in software that tracks pets, for example. It didn't work. Guess what? I'm gonna track, maybe older people or maybe tracking birds or whatever, right? When should I? What is it? When should I inform the IRCC? As should I inform them, or I just wait for them to ask for an update? And then I said, okay, guess what? I did this and that, and I spent that much on money, and there's the proof of my first applied idea, and I have pivoted, and this is my progress. What's your advice around this?
My advice on that is before I actually contact IRCC, I would first contact the designated entity,
Mm-hmm.
right? And I would explain to them, here's what's happened. We've put our best efforts and we've run into this issue, and here's what we're proposing. So maybe we're going to take a slightly different approach, or maybe a significantly different approach. And that engagement should first determine with the designated entity, does this pivot fall within the certificate, or is this fundamentally different? And we've seen this before. And sometimes what will happen is the designated entity will do another sort of round of due diligence and bring in experts to then assess where this company is planning to go, and then update the certificate, right? And then at that point, I think then you can update IRCC to put them on notice that we've done everything possible to make this happen. We've engaged with our designated entity, and we're now going to vary our business plan. Here's what we're proposing to do. So when the officer ultimately starts asking more questions, he's not going to ask about the first plan. He's going to ask about the second plan, which will be in line with what you did. And even where there are questions about what happens if I fail, right? And Pushkar touched on that too. It's not really about your success in what you tried to do. It's, did you try to do it, and how active were you in trying? And so just like anything else, like if you are running a startup business, if it's not working, go back to the designated entity, rethink it, but paper it, and then continue, right?
I got you. So before proceeding with the Q&A, I just want to respect your time, Alif, Pushkar, and Laman. I know that our first plan was to have from 9 to 11, but we were waiting for the opening of the presentation, and then we have some technical. So now we are beyond the 11. So if you have time, I still have lots of questions, and I have lots of people are mailing me just like they want to contact you. But it's up to you. It's either we postpone it to another meeting and have another continuation, or maybe we have another 30 minutes with you. It's up to you, and leave it to you.
I think on my side, more than happy to continue while everything's hot, right? We can continue. I'm not sure, Alif and Pushkar, does that work for you?
Yeah, I'm good with that too. Yeah.
Perfect. Okay, so let's go to the another question. They are saying that should I register a business in Canada before submitting my PR and work permit application? I believe I should avoid it, as the CRA would then have my exact sales and expenses starting from day one. Okay. So what do you think?
Well,
That's an easy one. I think, yeah, sorry. I think case law is already established that you don't necessarily need to establish a business. And the reasons can be the CRA or anything else. But the fact is that you do not need to establish a business before moving to Canada on a work permit under the starter visa program.
Actually, Pushkar, maybe this question also, because I have heard this also from applicants, because there is many, talks around this, is that if you registered before coming, this is a proof of seriousness, or maybe it is like something like an added star to your business. And that's why this is a trend also in my application. I can see that many of them, they even postpone me. Don't please issue my letter of support until I register. So maybe now you have like banished this notion. They don't have, but I think that I've read, I don't know if this is right, that before issuing the PR, they are mandating you to be registered, right?
Yeah, so there are two aspects to it, Naman. One is what the law requires, right? What the regulation is, what case law says, and the other is the best practice for success,
Yeah.
right? It's not mandatory. If you have it, it'll be good to have it. That's that's how I'll phrase this. All right. So, and there's a difference. If you don't have it and you come to us at a later stage saying that this is what the officer is saying, well, I would argue that it's not a requirement, right? But if you're coming to me, I may advise, okay, if you have the means, incorporate.
Okay, interesting. So I think this is clear. Okay, the other question is that they are asking you, what is the future of the SUV visa program, work permit conditions, and the number of years allowed? Allowed for what? So they are asking about the future of the SUV visa. work permit conditions and the number of years allowed. I don't understand what is the years allowed. If you could just like send me in the chat, what do you mean about the number of years allowed? But maybe Norman or Alif, Pushkar, if you could like make like a few insights. What's the future of the SUV program? What do you
So
see?
yes, if you look at the stats, as we've seen earlier, the inventory is rising faster than the amount of processing capability they have, right? So I think, and we've seen this in other streams, like in the federal skilled worker, which is our PR stream for professionals, right? It used to be that it got to the point where it would take 7 years before a decision could be made. And the startup visa has sensitivities because the startup has a life of about 2 years where that opportunity has to come together, right? So I think what we're going to find at some point is a redefinition of the program. They'll have to do a number of things. Either one approach is to start reducing the number of applications they take in, because you can't keep it open and expect that you're going to be able to manage a program. And we've seen that before where they cap a program, or where it's critical to bring in a certain quality and you don't want to cap, and capping would be bad for the program generally because other countries have more robust programs. The other way is to start creating some selection criteria like an express entry pool for SUV, meaning you may have to then start selecting out of the group of candidates which applications are awarded preliminary benefit. That would have to be through some ministerial instructions, and pull them out and exercise your resources to focus on them. This originally was a program where there was no work permit. The idea was bring them in for PR, and it's tough being on a work permit. When you have PR, you can raise money, you get investors are more comfortable. So I hope, and our policy paper is pushing the idea that this is where the program should go. In the interim, I think you will not find open work permits in this environment. Immigration goes hand in hand with the economy. And we see a global recession starting to creep up louder and louder. And so I think it wouldn't be wise to issue 3-year open work permits where nobody tracks what people are doing. And in fact, this employer compliance measure intends to do exactly the opposite, which is we want to track you. So I think you're going to find you'll have 1-year open work permits. They'll check in with you, but if you continue to do what you're doing, you can extend. And then at some point, the new minister has been in power for like 4.5 to 5 months. It usually takes 6 months for them to digest everything. And then I think at some point we're going to find a redefinition of this program to deal with these issues. So take advantage while you can in terms of filing, but I think there will be some additional screening measures introduced.
Interesting. So he replied in the chat, and he was asking about the how many allowed. He means how many they are allowed to keep renewing the work permit. Is there a limited number of years?
No limit. So the idea is the work permit should continue until a decision is made on your PR application. So you have a fair chance to come to Canada and make it happen, because it's taking so long right now to get to the PR.
Yeah, and a note about the extensions is another requirement for a work permit extension under this program is that you have a PR application that's still in process. So if your PR application was refused for whatever reason, you would no longer have a basis to apply for the work permit, because of the work permit is optional for the PR application, right? So at the very basis, at the very core, it is for PR, but it's just so that you can come to Canada and work until your PR application is either refused or withdrawn or approved. So as long as you have your PR application in process and it hasn't been finalized yet, you can continue to extend your work permit until a decision is made.
Interesting. I have one question that's coming to my private chat. It's asking, is it possible that the SUV team do not apply for any work permit, only work remotely from their home countries?
Yes, well, so theoretically, yes, it is possible, and the work permit is optional. And in fact, with some of the individuals in the matching scenario, what they do is they definitely don't want the work permit, because when you get the work permit, as you see, then the question becomes from the officer, what did you do on the work permit? And if you were not genuinely committed, you don't really want to be exposed for that. And now there's a compliance review too. When you get a work permit, there's a compliance review. If you don't get a work permit, you're not subject to the compliance review. But, and this is a big but, if you file an application for PR and you don't get a work permit and you stay in your home country, they'll also want to understand, how are you demonstrating your genuine intent to run a business in Canada? Right? So what you would have to consider, in our opinion, is explain why you couldn't come, why you elected not to, and then be very active remotely. So in the world of remote business, there are still many things you can do from your home country without being in Canada, right? And we would suggest you take that activity tracker and be as active. So that would mean contacting potential clients, developing a marketing plan, working with local law, all of that you can do remotely. And so the short answer, you don't need the work permit, but there's a higher obligation to show your activity when you've never been to Canada and you've waited 3 years.
Okay, and just to confirm, Raman, the 5 of them, all the team members, we shouldn't even mandate one of them to be in Canada. Can all the team be outside?
So I'll go back to Pushkar's comment. There's what the law and the policy permits, and then there's what's reasonable. So what we would think is, if they're essential members and they're really keen on launching this business, that there should be the essential workers, someone should be coming in and actively engaging and making it happen. If the other people in the business, for example, let's say there's a technology development center that's supporting the R&D for this Canadian company, then it might make sense that they're managing that piece to support the Canadian company. So I think what you have to do is look at the actual business and then make sure that it's logical, that you've got a balance between people doing what needs to be done. If there's on-site activities, it doesn't mean the whole team has to come in. But remember, if they're essential, typically the idea is that they would be coming in because there's something urgent that they need. So it kind of goes hand in hand. Who's essential? What are their activities? And does it make sense from an officer when they look at this group that they were genuinely committed?
Okay. Okay, another question related to the same question, which is, okay, let's say I'm the applicant, and we are 5 team members, and the 5 of us, we don't want to come. According to the law, this is allowed. And I still in my home country, so basically I'm not registered in Canada. I don't have a business account in Canadian business account, but I'm running the business in my home country, which means that I have no CRA file. I am not filing my taxes, and I'm coming to Canada. So for these 3 years before having my PR, how is the financial situation around the taxes will go around me? I don't know if my question is clear. Is there any obligations or any implications about my case if I have lots of financial interaction in my home country, and then I come after 3 years starting from the 0 point? I don't know if I'm clear.
If we understand this correctly, and I'll let Noman take it over after this, is it regarding the fact whether there are any tax implications to the business that you are running in your country of residence that you are yet to establish in Canada?
Yes,
Okay,
exactly.
so 2 points to that. One, we are immigration lawyers. We may not be the best to advise on tax issues.
Okay.
However, to pay tax, and this is what we understand, to be paying taxes in Canada, you need to be a resident for the purposes of paying taxes, right? For CRA purposes. So the implications may not arise. And I'll leave it to Noman to add to this.
Yeah,
Okay.
correct. I don't believe that in that scenario you described that there's any immediate tax consequences. If you haven't been in Canada and there's no, registered business and there's no activity. But to me, the concerns that if I'm an officer, number one, if I see 5 co-founders in one certificate, I become concerned that that's a risk factor. You usually won't find 5. So that's often when you have the matching scenario, you'll find 5. So, and then the other factor is, many times when you've got 5 individuals and none of them want the work permit, that's also an indicator that they may not really want to be in Canada, but they want to see if they can get PR. So that's 2 kind of strikes, right, that you have to consider. So to me, I would tell that group that if you're genuinely committed, it would seem to be increasing your risk profile if nobody comes to Canada and you're just all working remotely overseas, creating this company that has no papers, no incorporation, no potential customers. It's hard to demonstrate that your idea is still relevant and fresh 3 years later when no one even came to Canada. So that would be my first impression. So I would say I would rather have one or two people of that group at least come into Canada and actively get involved and deal with the tax piece, because those are the steps that, if you think about that employer compliance review, the first thing they're looking for is incorporation, finance, and tax. So I would kind of argue it. Yes, the law doesn't allow it, but it's a big uphill hurdle if all of you are in a foreign country and none of you have come and you haven't actually started anything.
Okay. Interesting. Makes sense. Okay, so the other question is for the team members. So now you mentioned 5 team members, and this is interesting because this is one of my questions that appeared while you were discussing. So we have cases like 5 team members came, or maybe 3 team members came, and everything went well, and we started the application process, and pop, after issuing the letter of support, the team separated.
Yeah, happens a lot.
Yeah, which makes it lots of implications on us because now we have to go back. And so I would like you to emphasize on the importance of how to select the team and how important the application. This, you don't want to have like red flags on your application, and you don't want you don't want the IRCC to take lots of care about your application, right? And
Yes.
these things will make like lots of hassle around you. So maybe you have a note or insight about how careful you should be while choosing your team members.
When you choose your team member, it's like choosing your spouse or common law partner, right? If you have a divorce, the next person's going to be suspicious, right? So I think when you are picking your team members, the first thing you have to understand is that this is a commitment, and we all have to agree that we're going to make best efforts to see it right through to the end, and that there will be challenges. There will be a time where we'll have to work. Any startup will have ups and downs. The immigration process is lengthy, right? You don't want to be in a position where you have a team, you're issued certificates, part of the due diligence is based on the strength of the whole team, and then halfway through, the CEO leaves. And now you're left with the CFO and the marketing manager. And now the question would be, would the designated entity, if they knew that that was the state of affairs at the time of issuing the certificate, did they just lose like the key person that made that business work? And would they have to maybe now look for someone, a new leader, which means they're talking to you, which they should do. And then you would have to figure out, how do you feel about the certificate? And maybe it's a person who was nice to have but not critical. So now you're amending the certificate and you're explaining to IRCC how the business will continue without this person, which I think is the prudent thing to do. But if it's a critical person, you might need to also find like another person that fills the gap. And you're right, Nermeen, like as you see this roller coaster of people coming on and off, what do you think the officer is thinking? He or she is really wondering, like, was this genuine to begin with? And we've seen in the matching, often what happens is the group comes together, but they're not really connected. And when they come in, things start falling apart. And so then you see this movement and reissuance of certificates. So again, it's a red flag. So, you're putting time and money into this. Think carefully and make an agreement with each other that we are going to see this through, and only bring them into the team once you have a trust level. And, things do happen though. We've seen it. It's quite common where someone breaks off. There's a dispute. It happens in every business. It can be managed, but, do that due diligence upfront to avoid pain down the road.
Yes, you're right. Okay, I still have lots of questions. I don't know if you have time for all of this. Maybe I can send them to you and give me answers, or would you like to proceed? I have lots of questions. What do you think?
How are you guys for time, Alif and Pushkar?
I can keep going. Yeah.
I may have to drop off the other.
Oh, I'm so sorry, Pushkar, but I still have about 40 attendees, and we have lots of questions.
So Alif and I will keep going, and
Okay.
And then anything that we will update Pushkar after, and we're enjoying it, so we'll continue.
Perfect.
I'll stay for about 10, 15 minutes. I think it starts at 12:45, so I have a
Okay.
breather.
Sure.
Thank you very much, Pushkar, for your time
Oh,
and
my
Nauman
pleasure.
for your flexibility. Thank you very much.
Sure.
Okay. The other question says, okay, study permit route versus startup visa program route for PR, time wise and money wise. So again, he's like he wants to come to Canada, and he has like both options. What's your recommendation, time wise, money wise?
So, well, money-wise, it depends on the program when you think about a study permit. If you're going to go to like, a expensive university and you're doing a 4-year program, you have to think about your cost. And then you have to remember most people that qualify after they get a study permit, they have to complete the program, then they get a post-grad work permit, and they've got to find an employer and they've got to get the right work experience. Typically, after a year, then they're qualifying for Canadian Experience class. But it's getting competitive. So I think the first thing that we would do with a client like that is look at their current circumstances, measure their points, project how long it would take, look at the cost of schooling, right? And then know that they're not earning income until they're, typically on the post grad. They can work, on campus and off campus in between. But in terms of full-time employment, they're going to have to wait for a period of time. And we would do that calculation. And then we'd look at the strength of the business plan, like the startup plan that they have. If that plan looks like it's viable, it's profitable, and that they have clients potentially, they've done some level of validation, they have experience doing that business, that would be, I think, how you would measure it. Yes, they have to pay for there's incubation fees, right? And then they're going to have their settlement funds, and they're going to have to provide for themselves. So part of it is to determine at what point would they end up being profitable, right? And then I think we weigh the two of those. You would probably get your PR faster if everything goes well in the SUV program, because like if you're talking about 2.5 or 3 years, the student would still be studying at that time, probably finishing their third or fourth year, and then they have to work. So then it's a question of speed versus cost. Do you value the education or do you value the experience of running your startup? So that's how I would weigh it with them, and then do a little analysis and let them make a decision from there.
Interesting. Okay, so another question from an applicant. She says that on recent update request letter, IRCC is asking startups that are not in Canada and while their product is not yet ready, what fundraising efforts they have done. How should they address this question or this request from the IRCC? So they don't have a product yet and they're outside Canada, and the government asking them about the financials, what is the fundraisings, and maybe other questions related to the money part of the business. Should they address this?
Does anyone want to take it? If not, I can take it.
Yeah.
Yeah, go ahead, Pushkar. Let's hear
Okay.
it.
So again, it stems from what they filed in the application to begin with. So ideally, now in such a scenario, we would first look at what was provided initially in the application, right? And then to understand further if there are any updates that have been provided to the IRCC with respect to the business, and thereafter look at the concerns of the officer and then reply. So this is a classic example of what a procedural fairness letter is, right? The officer has certain concerns. They are granting an opportunity to the applicant to disabuse those concerns, right? So now there is, it goes deeper. You have to, I mean, so as lawyers, we interpret it first. We try to understand, we read the provisions that are cited and try to understand what exactly the officer wants to know and what are the concerns, right? If the concerns are not laid down clearly, I would also highly recommend uh, doing an access request to get the officer's notes to understand what the officer's concerns really are with respect to asking these questions, and thereafter reply. But again, it's a case to case basis, and we need a wholesome picture to advise on what to reply to a one question. Like, I mean, we need certain further facts to advise aptly.
And let me add one little variable. Sometimes you'll get these questions asked by the officer, but the officers use templates, and they're not always thoughtful about what your circumstances are. So again, individually responding back to where your business is, what the plan is, and educating them might be enough. It doesn't mean you've necessarily done something wrong, But we see a lot of templated responses where some of the questions are totally not relevant to this business. They've just used a drop-down field. And as Alif mentioned, sometimes we've seen them refuse an SUV work permit based on a finding that they didn't qualify for some other work permit, which means they were totally lost, right? So just keep that in mind too whenever you get those types of requests.
Yeah, and I think also when you're responding to IRCC, if you see like a question that doesn't quite make sense to you, I would still address it. You should never not respond to a question that IRCC has asked you, even if it isn't quite in line. And I would also respond in a way that is meaningful. So you don't want to say just one line that says we haven't done any fundraising, right? I don't think that would be sufficient. I would try to maybe engage in a conversation and kind of discuss it in your response and say, these are the reasons why maybe we haven't, but maybe we'll turn our mind to it in the next month. And then you'll kind of set some benchmarks for yourself as well, because even though these may be templated, it could also be the case that the officers maybe providing you some guidance and hinting at something that maybe you should be doing, right? So for example, if you haven't incorporated your business and you're 2 years down the line and the officer says, please provide incorporation documents or proof of incorporation. Since you haven't done it yet and the officer is asking for it, it's not necessary that you do it, but you should maybe pay your mind towards doing those activities. So it's kind of like the officer might be pulling and maybe guiding you a little bit so that you're kind of getting a good picture of what he's asking for and what he expects to see in the next request letter.
Let me add one comment, because the comment Alif made about meaningful response is very important. It could have been, for example, that in developing our product and our offering, there's been a change in the market. And so before we're looking to seek financing, we are readjusting or adding features to address the market availability. And we now will put the financing aspect in the third quarter of the next year. That's totally logical. Right? So a part of it is, again, educating them, updating them. What they saw was a moment in time when we were projecting what was going to happen in the business, but then real life happens. And so I think that's what I would do. Engage in a detailed, meaningful way, show them your benefits and what that plan is with financing, even if it means that it's going to be restructured based on current changes.
Yes, exactly. So another question, I think that we have discussed this before, is regarding to the business proof of fund. But we're going to have a part of this question is that, is there any safe range of how much business proof of fund we have to provide? So the settlement proof of fund is very clear because it's a table in the IRCC website and they can go there according to the family member. But it is somehow confusing when it comes to the business. So is there any safe amount of money that they have to show in order to feel like, okay, this is securing my application?
So the good thing about that, and I'll let Alif comment on these because he does this every day, looking at the funds and then crafting submissions. The good thing about this bit is the investment funds. They do not have to be of one applicant. It can be a group. So 4 of you coming together and showing that you have sufficient funds to sustain this business and to grow it. That's the good thing. So if your proof of funds for your family is say 25,000 based on your family, the number of family members that you have, and you're providing 50,000 in proof of funds, you can definitely file in a submission to say that these additional funds may be utilized towards investment purposes if required. If it's a part of the plan, then you carve it out and you mention that these are my savings. This is a fixed deposit that I've maintained for investing. And similarly for the other applicants. So you can all come together, create a pool, and say these are the investment funds from us. And I'll let Alif add.
Yeah, no, I think that was great. I think that's exactly what they would look at. I don't believe there's a safe range necessarily, because it's also not really stated specifically in IRCC's policies or the regulations. Obviously, in these kind of situations, the more the better, just so that the officer can see something that's strong and there's a high level of commitment there. But I would say as long as you can show a reasonable amount, depending on where you are in terms of your business plan and where you see the business going 2-3 years. I think whatever is reasonable at that stage when you submit your application, and then you can revisit it as well a year down the line when they ask you for an updated information letter from IRCC for the PR application. I think whatever you can show during those 2 times, as long as it's reasonable and it's kind of in line with your business plan as well, then there's no real cushion or minimum amount that you would need to show.
Interesting.
If they both, both Pushkar and Alif nailed it. It's not a regulated, stipulated amount. Officers, whenever they're making a decision, it's about reasonability. And part of it is, have you explained how you plan to finance the business? Maybe initially you're going to bootstrap it, right? But then there's a plan as to when you get traction, how you'll take it to the next step, like any startup. But when you say nothing, well, then you're in the hands of an officer, right?
Yes, exactly. And that's why we use in our commitment certificate, when I write it, because there is a specific, boxes for the financial plan. And I always keep it open, is that
Right.
there's always opportunity, because we as North Forge, we offer them lots of, investment opportunity through our network. And we always mention that it's not only what they are providing, there's also lots of opportunity for them once they come to Canada, register the company, to have lots of other funding in order to proceed and to progress. So yes, we try to support as much as we can in the official papers. So
That's great.
the other question is really interesting one. Is they are saying, can we use real estate, for example, landed property, as a means of a proof of fund subject to evaluation? This is amazing question.
Yes.
Yes, you can. Yes.
Perfect. That's perfect. Okay, the other question is work permit? Oh, we have answered this one. It's related to the 3 years or one. For now, Ahmed, it's only 1 year. The 3-year work permit is not applied yet. So what is the reputation? Oh, this is a amazing question. So the question is, what is the reputation of North Forge letter of support? So I'm going to have it from my side, but maybe no, I'm not going to say it in a general, a designated organization. There is nothing related to the reputation. It is related to how much you are honest in your due diligence. We do our due diligence to the fullest, to the maximum, honesty toward our applicants first, because we are applicant oriented, and then toward the government. We will never do any act or any, action in any way that will fraud the government or mislead the applicant. So this is my only simple answer for the reputation, but can be done out North Force, because we are a set of designated organization, and maybe Norman could answer much more perfectly than me.
Yeah, no, I think you did a good job. I mean, it starts with integrity, right? Does the designated entity have integrity? There are a couple of things I'll tell you from being in the industry, and my colleagues will share that with you. Look at be aware, if you have an advisor, look at the federal court cases, and you'll see who were involved with cases where it looked yucky, right? And they've named them. So and Northport has not been named. I'll tell you that. The other thing is, look at volume. Like, not always, but you'll see that where the volumes are extremely high, it begs the question, like, how do you keep up with that volume of due diligence unless you've got the infrastructure? So if you have an incubator that's very small and they're producing massive certificates, these are issues. Here's another one. How rigorous was the process of getting through that due diligence? What questions did they ask? Did they seem like they were wise business questions? Did they challenge you? Did they really understand your team? Did they interview you? And like I said at the beginning, the more difficult they are, those are good signs that they have high integrity. If they're like wheeling and dealing and just trying to get you in the door and you get a certificate like in 24 hours, you've got a problem on your hands. So that would be the litmus test that I would give anybody out there.
Interesting. So the other question is, does international sales prior coming to Canada strengthen or weakness my application with the IRCC?
It's a yeah. I mean, these are all relevant factors in weighing in different considerations in an application. If you are going to be responsible for sales, right? And you're going to be the VP of sales for the company. The fact that you have a history of being able to produce sales at a high level adds credibility that you're capable and your team has the right ability, especially if sales is going to be a big aspect of how you grow your company. But there's no requirement per se, right, that you have to have a minimum sales perspective. So I think we're back to the theme of no, the law doesn't require it, but naturally these are helpful factors that you should, when Alif is putting the application together and he sees that sales are integral, there's probably a robust discussion about what skills are being offered in the startup to drive those international sales and how it will apply. And that will give the officer more confidence that this is a bona fide group that has the necessary skills to make it happen.
Yeah, and that takes us back to perfecting the application as well. So if we see during our conversations with the applicant that they're very strong in their sales, or maybe their business IP, for example, is something that is completely innovative and it's going to like change the game. That's something that we would highlight quite a bit in the submission letter. And so going beyond the four requirements, just the eligibility requirements for the program, it's important that you highlight as much as you can the strong points of your business. So if sales is something that you have before you submit your application and you have good traction internationally, then I would absolutely highlight it, because the officer, he will not look at one individual item. He'll look at the totality of everything. He'll consider everything that you submit to him, including all of the eligibility requirements. So it's important that, wherever you see your SUV or even the individual applicant's experience and capabilities, wherever you see it shine, I would 100% highlight that in your submission.
Interesting. So I have a question related to the IELTS.
I'm
So-
sorry. Before I'm sorry. There is another event that our firm is involved in today. It's actually already begun. I would have to take your leave.
Oh.
I would have loved to stay, and these are very important and relevant questions, and we are actually enjoying it. If you see on our faces, I'll let Noman and Alif, of course, take over, and we'll stay in touch. And thank you for having me. And
Thank you very much, Pushkar. It was really amazing discussion. And actually, I have lots of questions for you in here, specifically for you. But I think Norman and Alif also know how to handle it, I'm sure. Okay. Thank you very much, Pushkar. And we will have another meeting for sure.
Thanks, Pushkar.
Yeah. So, Naaman and Alif, I have a question related to the IELTS. Actually, it's not only a question, it's a case that I am dealing with now. So a team from a country that is not privileged to have an IELTS easily. So they have to go outside the country so that to have the IELTS because of different political issues, right? And they have already IELTS, but it is expired. And all their IELTS are really, above 6 and 7. So it is already proven that their language is good. So the question is, can they use their expired IELTS to pass the work permit application of the PR?
Sorry, for the work permit or for only PR?
For both of them.
For both?
Or you just tell me what is the exit in here? Should they go out because it's not easy in that country?
Unfortunately, since it's a part of the eligibility requirements, they would require valid IELTS test scores. So they would have to get new scores. Yeah.
And that's right. And for the PR, it's a clear regulatory requirement.
Yeah.
And then on the work permit, we did see previous case law suggested that it wasn't necessary, but then they've created a recent directive, right, where they're suggesting that you do need that. Yeah, like you could try on the work permit to argue the difficulty and try to make a discretionary decision, but I would always caution the individual that they would be entitled to refuse. But you could try to argue and maybe provide other evidence of language, because technically, until recently, the work permit didn't have a regulatory basis for needing the language. So it's a little creative kind of effort, right, to avoid it. But ultimately, for the PR, they're going to need it. So probably makes sense to bite the bullet and just get it.
Got you. Okay. Another question. He said that I already incorporated a business entity back in India in 2018. Shall I disclose it to IRCC? So if you have a company already there, should I just declare that I have this in IRCC? But I don't understand.
Yeah, well, so firstly, it depends. What is the entity that will be the basis of the SUV application? Is it going to be a new entity that's totally disconnected? Do you have another pre-existing business for other purposes? If you do, that's not connected to the application. I mean, at least that would be my view. Now,
Yes.
what I've seen occasionally is that that other company, now they're going to create like an extension of that company. And then that becomes a tricky issue because you're supposed to create a Canadian startup company, and an essential part of that company should be done in Canada. So I think if there is a connection or a nexus between your business activity and that previous company, I would speak to a lawyer about that, because that could create an issue. Like, Pushkar had mentioned, there was a federal court case where it said it should be a new business, not an existing business. So that's where it can get tricky. If it's unrelated, then it's not relevant in my mind. I would focus on the new business that's being created.
Right.
But for this case, for example, Nama, it's a question, Nama and Hamid. So if they have a really good running business in their home country and they come to Canada, can't we consider that the Canadian branch is a headquarter, regional headquarter, because it's a regional headquarter, right? Why should they start? I don't know. It's a question. I don't know if this is applicable.
If you're going to create a brand new entity, and that entity is going to have an essential purpose, and it's going to have the right shareholdings, right? And you can describe the innovation, I think you might be able to explain the relationship between another entity that might be providing a support service. But what it shouldn't look like, and what it shouldn't be, is that it's simply just a extension of an already existing operation in Canada. And that's a fine line, what I described. So I think you would have to look at the merits of exactly what will be done in Canada, what the distinction is, and to demonstrate that that new entity in and of itself is really going to be driving innovation for Canada. And so, yeah, I don't believe the startup visa wasn't envisioned for this type of situation, but you're right, it does come up. So one has to carefully articulate the difference between the entities, and it's a slightly gray area.
Interesting. Okay, so this is a totally immigration question. So he's asking, or she's asking, does work experience while on work permit counts for express entry program? Just in case the PR not approved for the startup visa program, they were working. Will these years or experience working will be counted if they were accepted for the express entry?
Depending on, so I guess we would have to look at a number of factors: what they're doing, how the work permit was issued. Theoretically, there could be like some experience that's gained depending on how it's structured, if they're taking a role in the company. But one has to be very careful about that. Like to our earlier point, that you really, if you're an SUV applicant, you shouldn't be processed under express entry, because if you're approved, if there are any essential members, they're all basically going to be refused. So that consideration only should be relevant if, let's say you're a single member and for whatever reason you feel like you cannot continue in your SUV, and then you want to explore your eligibility in express entry. And then you look at the totality of all your evidence. You look, have you worked in Canada for a year? Is that self-employment or is that employment? We have to look at that issue. Then we have to look at your factual circumstances, your age, your education, your language, and then score you an express entry. But know that once you go down that route, you're basically on the track of abandoning your application and potentially jeopardizing your other applicants as well.
Yeah, you're right. Okay, so another question. So I'm going to phrase it in a way. So they're asking, so they have applied for the work permit and they were refused. And the question is, should we go to federal court to appeal the decision? So I'm going to rephrase the question, because yes, they can go and appeal. But my question is, if this applicant was refused and he is 100% that the business is ready and everything is real, and this is related to the officer misunderstanding, okay? The question is, should the applicant go by themselves, or should they go through their lawyers, or should we as designated organization be backing them up and going to the court? So how does this go? Who is the responsible for this procedure?
Right. Okay, so ultimately, when a work permit is refused, that application is the applicant's application to work, right? So they're filing that application. Now they have support from you in terms of the certificate being issued. So it's their obligation to manage this, in my opinion. Okay. Now, the first thing I would do is I would say that the mere fact that you receive a refusal doesn't mean that it's correct. The refusal is correct. We've had many cases. Alif has worked with me on many cases where we've overcome the refusal by explaining politely to the officer that they should reconsider and that they've made potentially an error in interpretation. And we refer case law and guidance. In fact, in our work permit applications, even on the first filing, we provide guidance to the officer because many officers are new to this program. So we explain exactly how they should look at the application. If they made a mistake in the refusal, we go back and ask them to reconsider. It saves you time because federal court could take you 6 months to a year when you go through all those steps, and it can be expensive. So I wouldn't start there. I would start immediately going back, and this is where I think counsel is useful to understand what their view is and their opinion. And only if we cannot get a decision overturned do we then consider whether we take it to federal court. And even before we take it to federal court, sometimes what happened is when the application was filed, it was defective. Like they failed to put in material information that they should have, and the officer was right. But the faster approach might be to refile the work permit properly than to go to court. So this is the discussion we have, and then we make an informed decision that makes sense given the facts that we're dealing with.
Interesting. So another question is, what is the recommended list of supporting documents in the PR application apart from the document checklist given by the IRCC?
This is a good one for Alif.
Yeah. This is anything that you can tell us about your business. That's very important because IRCC doesn't actually require you to provide that document, and it's not going to be on the checklist. So you should definitely try to provide as much information about your business, your qualifications, your business plan. So what you'll be doing in the next 2 to 3 years until your PR application is approved, what the benefits are to Canada, that's very important. You can highlight those, what the innovation is. All of that information is a part and outside of the document checklist, but it's something that all of the officers will look at and they'll ask you questions about. So it is a good idea to, again, perfect your application, submit a complete application package with all of that information, anything that you think the officer should know, and anything that you want to highlight to the officer, strengths about your company and you as the applicant, all of that should be put into the submission.
Interesting. Okay, so the other question is, how about if the applicant wants to change the business? Okay, we have discussed this before. So now there is a question that I wanted to highlight. Can we apply? Yeah, this one. Can we apply for a work permit before applying for PR? I guess earlier it was allowed, but they changed it recently. He just want to make sure. And I think this is the new regulation, Alif, right? They have to apply first for the PR and then work permit, right?
That's right. Yeah. So the work permit is premised on the fact that you have already submitted a PR application. Our process, since we leverage technology a lot at our firm, so we actually prepare both of the applications simultaneously, and then we submit the PR application, let's say in the morning, and then the work permit we submit in the afternoon. So technically it's the same day, but we prepare both of them at the same time. But you should be submitting PR first and then the work permit.
Interesting. So one audience is asking about, did the priorities that were given previously for VCs, angel investors, and incubator in the CTN network since last June, is this applying? Is this still showing? Or it's just paper, words on paper? What do you think, Alif or Nauman?
I think, is this in reference to the minister's announcement?
Yes. Yeah, Shane Fraser. Yeah, the latest announcement that there's a priority for VCs, angel investors, and the CTN network incubators, and North Forge is one of the CTN.
All of those were described by the previous minister, Sean Fraser, and he announced it, and then he left. He got shuffled to a new cabinet ministry, and so I think you can say there is no directive that any of that will come into play. That was a suggestion. And in talking with the department, I think the minister was ahead of the department in making those. Those are initial announcements. And then they had to go back to the department. And now you have a new minister. So personally, I think you can just assume that all bets are off right now on that.
Interesting. So the other question is, this is interesting one. So he's asking, or she's asking, will work permit be revoked if the PR processing times return to normal 6 months?
First of all, if we ever get to that, that's a wonderful problem to have, which I highly doubt. I think they would have to redo the program. Like right now, the ministerial instructions allow for the work permit. They would only do that if they decided, for example, that they were going to reduce the inventory and select only a handful of cases, and they could process them within, 3 to 6 months. Then the work permit wouldn't be necessary. So it would have to be a massive shift in the whole program. I don't see that happening anytime soon.
Interesting. So there's a question about how much do you charge to handle the PR application. So I believe this has to be privately between you and Greenberg. I have shared their emails, and after this presentation, I'm going to share the recording and the presentation, and their contacts as well. So maybe you can go back and ask them immediately. So another question is how much? No, not this one. Um, what else? So I think most of the others are we have already touched based on, and a question. I have one question related another case that we have already in hand, but I would love everyone to hear the answer. Is that in some countries, such as, for example, Yemen, where there is now a war, right, and some other, unfortunately, other countries worldwide. So, and they want to apply, but now they cannot get a police check from these countries that they have spent more than 6 months. So what is the exit in these situations?
So for the PR application, you don't actually need to have your police clearance certificates at the time of application. So you can submit without it, but IRCC, they will ask for it after about a year in processing. And so if you wanted to just submit your application without the PCC, I would definitely tell the officer in your accompanying letter that you intend on obtaining a PCC when it's possible to do so, because it may not be possible right now. And then just give some information about the situation, and just describe to the officer what your current hardships are in obtaining a PCC. If it's not obtainable at the start of the process, just let it be known. I would definitely address it rather than submit it without and then stay silent. That's not something that you should do. So definitely put the officer on notice that you've attempted to get a PCC, but it's not possible currently, and that you provide it at a later date. And then the same thing would happen for the work permit as well.
Interesting. Okay, so now we have about 15 minutes, and I would love to have like a networking, because I've been asked, some people want to talk to you one-to-one. So I would like to thank Alif very much, and Nauman very much for your flexibility, and Pushkar for as well. It was really an engaging discussion. We have exceeded our time, and we have, and thank you very much for your, generosity in the time. So now we're gonna go to the networking, and again, I'm promising everyone that we're gonna share everything, all the resources for everyone, including the contacts if they have any specific thing. So thank you very much, and now we're gonna go back to the networking mode. So you're gonna find lots of tables that is labeled. Please feel free to double click on any chair that you would like to talk to people, including one for North Forge, where I will be sitting there. Nauman has his own table. Alif, maybe you will join Nauman at the beginning, and once you want to have your private discussion with someone, you could invite them to your own table. So thank you very much. We have 15 minutes for networking, and then this session will be closed. Thank you very, very much.
Thank you, Nermeen. We really appreciate it.
Yeah.
Thanks,
Look
everyone.
forward to networking with everyone.